In recent decades, in vitro fertilization practices have become normalized in the United States. But a recent decision by the Alabama Supreme Court holding that the loss of a frozen embryo is covered by a statute aimed at wrongful death of children may trigger a wave of state-level activism that could force people using IVF services to receive substandard medical care. I'm Stephen Morrissey, managing editor of the New England Journal of Medicine, and I'm talking with Alta Charo, a professor emerita of law and bioethics at the University of Wisconsin at Madison. Professor Charo has written a perspective article about the Alabama decision and its potential implications. Professor Charo, could you start by explaining how IVF works under current practices?
Of course. Today, best practices in IVF involve trying to minimize the risk to the woman by limiting the number of times she has to undergo induction cycles and egg retrievals. And to do that, typically, as many eggs as possible will be taken originally from the first induction. And after an effort at fertilization, those that have fertilized successfully will be used for pregnancies. Ideally, one, maybe two fertilized eggs are put back into her body, and the remaining ones are frozen for further use in subsequent cycles. An additional advantage of this, at least in the past, has been that in subsequent cycles, her body may have had a chance to rest from the induction process, and that might also have an effect on the likelihood of a successful pregnancy. So the current best practices, by minimizing the number of times she has the induction and the number of embryos put back in any one cycle, has the effect of requiring that some embryos be left frozen, awaiting further use. That's exactly the kind of thing that might not be possible any longer if decisions like the one in Alabama were to be adopted in other states.
So, looking at that case, the case of LePage versus Center for Reproductive Medicine in Alabama, what were the facts in the case?
The case is actually somewhat peculiar. There was a mishap that resulted in the loss of some stored frozen embryos, and the people whose gametes had been used to develop those embryos were looking for a way to get recompense. Now, there are other avenues, including things like ordinary negligence, but they specifically were looking to get recompense under a particular statute that had some procedural advantages for them, and it's called a wrongful death statute. These were originally adopted many years ago when a peculiarity of English common law and then American common law meant that one could get damages for being injured, but if one were killed, one's relatives could not recover anything at all. It was almost better to kill somebody than to injure them by virtue of negligence. And so the wrongful death statutes had a very specific purpose adopted in the context of very specific kinds of injuries to already live-born people. They were never, ever adopted with an eye toward how they might affect frozen embryos.
And then what was the court's decision and how did that play out?
The court took a look at the language of the wrongful death statute and combined that with its own interpretation of what constitutes a child or a minor. Actually, the word was a minor. And in addition, they looked at some language in the Alabama Constitution that was aimed at indicating Alabama's public policy in favor of promoting live births, and came to the conclusion that together these influences required them to interpret the wrongful death of minors statute to include embryos. Implicitly, and in the case of the opinion by the Chief Justice, who was concurring with some very biblically based language, explicitly, it equated frozen embryos with live-born children and gave them the same legal status, at least under this one particular statute. And this was the first time that you had seen that happen in Alabama.
So, in fact, how have courts and legislators previously approached these questions about the status of embryos outside the human body?
With a great deal of confusion. So we have to start, I have to mention the phenomenon that in the US, we have a federal system, and each of the 50 states and various territories have the ability often to come to very different conclusions about things. In the context of frozen embryos, we see cases developing starting in the 1980s when IVF is first becoming popular, which there are conflicts over what to do with frozen embryos. Sometimes it's because an embryo has been lost or damaged. Sometimes it's because people who made the embryos, whose gametes were used to make the embryos, can no longer agree on what should be done with them. This particularly would happen in cases of divorce. And we see the courts struggling to fit frozen embryos within some legal paradigm that makes sense under their respective state laws. One of the earliest cases had to do with who controlled whether or not somebody could take an embryo. And in that particular case, you see the courts talking about the embryo as if it were property. And the question about who gets to control where it is or how it's used would be decided by the usual rules about property and ownership. Later, in probably one of the most seminal cases here, no pun intended, we have a 1992 case out of Tennessee in which a divorcing couple can't decide what to do with frozen embryos. And we have the interesting phenomenon of three different courts at different levels coming up with three different conclusions. The trial level court decides that the frozen embryos should be treated as children. And all about the case and the decision about who gets to control should be decided along custody lines. How do we decide custody? We ask what's the best interest of the child. And the court then took the step of assuming that the best interest of an embryo is to be brought to term, ignoring that the embryo has no sense of self or any interest one way or the other, but takes this kind of omniscient view. It's better for the embryo to be brought to term. And so using custody rules for children, the court would award the embryos to the parent who wants to bring them to term. The intermediate appellate court instead reached back to the earlier case and said, no, actually, we've got a little bit of precedent from a different state that treats them as property. We should be deciding this along property lines. So we should ask, how is property divided in a divorce case, and use that decision. And there are examples of property that's not the same thing as a toaster oven, property like a pet, for example, where often you have this phenomenon of needing joint agreement about how to handle something. And then it goes to the Tennessee Supreme Court and they say, no, 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 no. It's not a child, but it's not a piece of property. It's something else. But they never really get to telling us what that something else might be. And so in the case of the Tennessee Supreme Court, they kind of send it back with a decision that you really have to have these two people work it out between themselves. And the reaction to this series of decisions in Tennessee was for IVF clinics around the country in other jurisdictions to begin to be much more careful about making sure that before people began IVF, they actually sat down and talked about what might happen if, and then wrote out a series of outcomes. If we divorce and one of us wants to use the embryos and the other one doesn't, who gets to have primacy? And that kind of pre-agreement became a norm. And it was a way of avoiding, in some ways, the question of the status of the embryos, because instead we used a contractualist approach and let the gamete providers or the intended rearing parents, usually gamete providers, but not always, let the intended rearing parents make the decision for themselves. And so sidestep the issue completely for a very long time.
And then getting back to the Alabama decision, how have policymakers there and in Washington responded to that decision?
Well, it's been very interesting to see how the people who have taken an absolutist position about abortion and premised it on the idea that from the moment of fertilization, you have a human form of life that is the moral and ought to be legal equivalent of a baby. Very interesting how this kind of absolutist wing of our thinking in public has tried to balance that with what is very evidently a pro-natalist instinct. They are in favor of people having more babies. When it comes to people avoiding babies, whether it's abortion or even contraception, they tend to be very, very disapproving and often very interested in legal measures to limit the access to things to prevent conception or prevent birth. But they were often very supportive of things that involved making children. And so now they were really stuck. And we begin to see immediately a split within that community. So some of the really sincere absolutists continue to praise the decision and say it's yet another step toward us having a truly pro-life from conception kind of policy in the United States, whereas others were worried that this was going to prevent IVF clinics from functioning. Indeed, in Alabama, within a day or two of this decision, IVF clinics began to say, we are no longer going to offer our services until we can figure out what to do, because we're worried about our liability in case of an accident involving embryos, and we're stopping procedures even halfway through protocol. So the Alabama legislature reacted pretty quickly to public opinion, which favored having children by whatever means, and adopted some legislative measures that would insulate IVF clinics from liability under this wrongful death statute for negligent loss of embryos. In the US Congress, there were two bills that were introduced that would have done the same thing. And in the Congress, it was not possible to get those passed. And there was opposition from people who are from the more absolutist wing, including some people who had previously submitted bills in previous Congresses called Human Life, fill in the blank. They had the various names that would have given, at the federal level, a fertilized egg the same legal status as a live-born child. So we saw locally in Alabama, the panic led very quickly to an agreement to protect IVF clinics, regardless of its consistency with this more seemingly strongly held position about sanctity of fertilized eggs. But in the US Congress, where it only takes a couple of dissenters to stop things cold in their tracks, we saw that we couldn't go any further in terms of protecting the IVF clinics. So far, we've had a lot of rhetoric in the other states, but we're not seeing any legislative action in the other states, but it's early days yet.
And finally, how could the reasoning in this case be used in areas beyond IVF? What other currently standard medical services do you think might be threatened?
I think it's important to first understand the way in which it might affect IVF practice, because prior to the advent of freezing, it was standard practice in at least one clinic that we visited as members of a congressional delegation to put back as many fertilized eggs as had been created, in this way avoiding the loss of any fertilized egg. That was a political move, as well as in the early days of IVF, a move to try to increase the chance of a pregnancy. But it increases the numbers of twins and trips, and it makes for a much more dangerous pregnancy for both the pregnant woman and for any fetus or offspring. So the first and biggest problem is that the inability to freeze may lead some clinics either to have repeated induction cycles. They only get one or two eggs at a time, which is bad for the woman who have to go through that, or they will put back more fertilized eggs, more early embryos than they would ordinarily do under good practice in order to avoid having frozen embryos in the lab. And that then risks the pregnancy. So that's the substandard IVF practice risk. When it comes to other areas that are at risk, one thing that is important to know is that we have now introduced, for some people who need it, a variety of techniques for genetic screening of embryos. It's particularly important for families in which there is a known genetic disorder, one that can be identified through a biopsy, through pre-implantation genetic diagnosis, biopsying a cell off of an embryo, and then giving people the opportunity to choose to transfer for pregnancy only those embryos that lack the known really serious genetic problem. So this kind of genetic screening of embryos that lets people use their own gametes, even if they have a genetic problem in their family, would certainly be threatened because it would involve the loss of an embryo that doesn't get transferred. It also usually would involve having a number of embryos frozen before you get around to doing the biopsies. And so that's one area that certainly is at risk. More profoundly, this really is yet another step toward a more absolutist position about the moral and hopefully legal status of fertilized eggs and early embryos, equating them to children in this area of law. We've seen other efforts like that in the past. There are laws already on the books in some states that have a different level of criminal liability or civil liability for injury to a pregnant woman if it injures the fetus, and feticide and fetal injury, which again are built on the idea of trying to treat the not yet born human entity as having the same legal rights as a live born child who might have been injured or killed by a third party. So it's about, in a sense, building a wall around the idea of the human entity prior to birth having the same status as a post-birth human, where that wall is made up of a whole series of bricks. Limitations on abortion, that's one brick. Feticide laws, that's another brick. Giving embryos the same status as a child under a wrongful death statute, that would be another brick, all leading eventually to an absolutely, completely impervious wall that would treat all fertilized eggs and early embryos as children.
Thank you, Professor Charo.